List.
Item number 1.
Yes.
Lordship, this is a writ appeal against the order dated 17/2/2025 passed by the learned single judge.
Yes.
Lordship, in preferring this appeal, Lordship, there's a delay of 13 days.
Delay?
13 days, 13 days.
You're controlling the delay. And what is the subject matter?
Lordship, this is for non-consideration of promotion and non-granting of third MECP, Lordship. Because he lacks ACR, that is the reason.
So there is no scope of any interim order.
There's no scope for interim orders, Lordship.
So the appeal can be heard out.
Yes, it can be heard, Lordship.
By filing of paper books.
Lordship, Lordship, we had enclosed all the papers in the memo of appeal, Lordship.
You see, paper book, there is an index, pagination number. It's a proper way of hearing.
Lordship, I'll prepare the paper book, Lordship.
Informal paper book.
Lordship, I'll do it.
Sufficient cause is shown. We condone the marginal delay of 13 days.
Yes. 13 days, Lord.
13.
13.
In filing this appeal. Next, this application under Section 5 of the Limitation Act is allowed. The registry is directed to formally register the appeal. Then you will get an appeal number, huh? Then in a separate sheet, the appeal is treated as on the day's list. It is from a judgment and order dated 23rd March 2022. That is order?
No, Lordship. 17 February 2025.
Which page?
Lordship, that would be at page 213, Lordship.
February 2025, passed by a learned single judge of this court. Now, from a part of the judgment and order, you are not, it is partly in your favor.
No, Lordship.
With the above directions, this writ petition is allowed. See the last line.
No, Lordship, we had challenged the entire order.
Allowed also.
Lordship, what has happened in this case, Lordship, the appellant was supposed to be promoted to the post of Subedar because he lacks ACRA, Lordship. Now the learned single judge has passed a direction whereby the respondents were directed to communicate the uncommunicated ACRA, Lordship. Now our case is that the uncommunicated ACR should not be taken into consideration at the time of promotion. (216) is the direction, Lordship. Page 216.
Well, this is partly in your favor, but what are you saying? You will make a representation against the ACRs.
Lordship, we are aggrieved by that direction, Lordship.
Then DPC will revisit the issue.
Lordship, our case is that the uncommunicated ACR could not have been taken into consideration itself, Lordship. Now, by going back,
So that is why you are asked to make a representation for
Lordship,
reconsideration of your ACR by the DPC.
Lordship, there are judgments, Lordship, which we are relying, which says that the uncommunicated ACR could not have been relied by the respondents. So, us going back to the respondent to represent that
Yes, what have you
does
written?
not arise.
Of this court. Although the operative part of the judgment and order says that the writ petition is allowed, within quotation, this writ petition is allowed to the extent indicated above, unquote. The appellant is of the view that the entire judgment and order is against him and full stop. He has appealed against the same. Paragraph. This appeal is formally admitted as the respondent is represented in court. All formalities are dispensed with. We expedite hearing of the appeal, filing of informal paperwork by the appellant, by 24th April, serving a copy 7 days before the date of hearing, list the appeal for hearing on 7th May.
7. Hello.
It is absolutely in your favor. Why you are preferring an appeal?
My lord.
Lordship,
There is no better order could have been passed.
Lordship, there are,
In fact, a series of orders in same direction has been passed by land single judgment.
Lordship, there are judgments which we will like to.
Because of him, because of his submissive arguments, we have admitted the appeal. You have a good ground to dismiss it at the threshold.
In fact, there is no ground for filing this appeal.
We will try to pursue it, Lordship.
The single bench will sit immediately.
My lord.
Highly bench.
Okay.
Yes, please.
Number one,
Please.
My lord, the petition has been filed for seeking a promotion. The petitioner was commissioned in BSF as an assistant commandant, my lord, whereby he was due for his promotion to the rank of second in command from assistant commandant to deputy commandant, my lord.
Yes.
Thereafter, he was supposed to be promoted to the rank of second in command, my lord, whereby he has been deprived of, superseded by the juniors.
Yes.
My lord. The
What are these orders? 19 December 2016? Asking.
my lord, that is a similarly situated person has been challenged that order, my lord, and Honorable Delhi High Court, my lord, has upheld, directed the respondent to give him the promotion. My lord.
19 December 2016 order
19 December 2016 order is, my lord, that is
does not concern you.
concern me, my lord. It's
Where is that order?
My lord, that is at page, my lord. At page 75, my lord. 45, my lord. 45.
Page 45.
My lord.
Then
My lord. Thereafter, my lord, again, my lord, on 28th April 2017, the respondent has passed another order.
pursuant to the earlier letter, the DPC considered you.
My lord, DPC, they said that 2 DPC has been constituted, my lord, in this letter dated page number 47, my lord. My lord has.
No, based on the recommended first letter, based on the recommendation of the Board of Officers, case of relaxation is mandatory course.
My lord.
In mandate, as well as in mandatory service will be processed
My lord.
to MHA.
My lord, that petitioner is not aware of, my lord.
No, this is the decision.
My lord, decision, but the respondent, the petitioner has not been communicated with. Page 45.
28th April is the decision that you have not been found meritorious. Now you are working as what?
My lord, at present I am working as a second in command. My lord. They have given me a promotion on 11th November 2017. My lord.
You are still second in command.
My lord.
No promotion.
No promotion.
Yes, Mr. Deputy, what do you say?
Well, few dates, my lord. Well, he was initially appointed on 5/7/99, my lord, as assistant commandant. Or else, your lordship, please, if matter can come tomorrow, I will prepare a list, my lord. Tomorrow,
Yes,
day
you
after.
could. Appointed on
5799, my lord. As assistant commandant.
assistant commandant.
My lord.
Yes.
Then he was promoted, my lord, as deputy commandant on 17/6/2006. 17/6/2006.
Yes.
Now, my lord, the next promotional post is second in command, 2IC they call it, my lord.
Yes.
Now, in 2011, my lord,
He was promoted to this post.
no, my lord. My lord, in 2011, he went on deputation to the governor house, my lord.
Yes.
He went on deputation to governor house on 23rd February 2011, my lord. And he returned from there. He was repatriated on 25/4/2016, my lord. So for 5 years, he was in governor house as ADC to the governor, my lord.
Yes.
Now, my lord, rules provide, if I may just take it over with the rules, my lord, in the writ petition.
Yes.
Page 63 of the writ petition.
Yes.
Page 63. But at the bottom of the page, lords will see by promotion. Deputy commandant in level 11 of the pay matrix of the Border Security Force with 5 years regular service in the grade with total 10 years group A service and possessing the following qualification. So, my lord, he was required to serve for 5 years as deputy commandant, my lord, for consideration for promotion to the next post, which is 2IC, my lord. In between, before completion of 5 years, my lord, he went on deputation to the governor house. And clause B, my lord, the lordship says this is what is
Where are you reading? Page 63.
page 63 of the writ petition, my lord.
Yes.
On page 63, lordship will kindly see the third table, my lord. This is in respect of second in command, general duty, column number 1, my lord. Lordship's got.
Column 1.
Now there are many 5 tables in this. The third table I am referring to, my lord, serial number 7, second in command. Lordship's got it.
Here the first column is Inspector General.
Page 63, my lord.
Yes, I see. Inspector General.
Different. Page numbers are different, my lord. The copy given to me.
You read out.
Page 65, my lord.
This is internal page 16, my lord. Your lordship, I don't know whether that's correct or not.
Yes.
My lord, in the middle somewhere, my lord, serial number 7 is mentioned.
Yes, second in command.
Second in command, my lord.
Yes.
So 542 posts, pay level is mentioned, my lord. And then at serial number 10 is mentioned, my lord. What are the rules, my lord, of promotion? It says, my lord, Deputy Commandant in level 11 of the pay matrix of Border Security Force with 5 years regular service in the grade, with total 10 years Group A service and possessing the following qualifications, namely, should have successfully completed pre-promotional course or courses as prescribed by the Director General of Border Security Force from time to time. Now, this is what is causing, this is the main issue, my lord, in the present.
Pre-promotional means
Well, before promotion, they have to undergo training, my lord.
before deputy,
At the time when he is deputy, my lord,
before second in command.
before second in command, to become 2IC, he has to undergo military this kind of training, my lord,
Before second in command.
before second in command. But the scheme is like that, my lord, because he has to serve as deputy commandant for 5 years. And during that 5 years as deputy commandant, he has to complete many courses, my lord. Or those are called promotional courses. Now, because he went on deputation to Governor House, my lord, he could not complete all these courses, my lord.
Yes.
Now, if I may take your lordship to my affidavit, my lord, and he was informed about this, my lord, very categorically, that you are going on deputation to Governor House and you may miss out on your promotion and other things. He gave an undertaking before going to Governor House that I forego, I understand that. Now, that is at page 50 of my affidavit, my lord.
Affidavit.
Page 50.
Yes.
So, my lord, he gave an undertaking that he is unwilling to undergo the trainings, and rather he is going on deputation to Governor House, my lord, and he gave an undertaking that I will not hold BSF liable for that. And he went on deputation, my lord, for more than 5 years, my lord. Is it the dates?
Now where is he?
So, my lord, the dates I mentioned, my lord, he went on deputation on 23/2/2011, my lord, to the Governor House, and he came back on 15/4/2016, my lord.
Page 49 also undertaking.
No, my lord.
He is still deputy commandant now.
No, he has subsequently he has been given promotion, my lord. He wants retrospective promotion, my lord. After he came back to BSF from Governor House, my lord, he underwent training, and then from the date of training, after taking into account other factors, he has been made to IC, my lord. The only issue is for that period during the Governor House, my lord.
My lord, the undertaking which my lord senior that is prior to, that is of March 2011, my lord.
Yes.
And my lord, the petitioner was selected by the authority to be go on deputation, my lord. He was selected. It is their own admission, my lord. My lord, if I take to para 5C, page 4 of their affidavit, my lord.
Affidavit.
My lord.
What are you placing?
Petitioner was selected, my lord. It is not at his own, my lord. My London senior is placing a case that its own wish, he went on the petition, my lord. It is not the case, my lord. He was selected by the
But
respondent.
your willingness was above.
Nothing was taken, my lord.
No, then why did you give the undertaking?
My lord. And for the 5 years, my lord, the extension was made by the respondents at their own, my lord.
Yes, please take it up.
My lord, that is at, my lord, at
When is the next promotion due?
Well, next will be due for commanded, my lord. At that time, I'll require some instruction on that, my lord.
Yes, please take it up.
Commanded, ma'am. Call him for this.
On 5/7/99, the writ petitioner was employed as an assistant commandant in the border security force. Next line. On 17 June 2006, he was promoted to the post of deputy commander. The next higher post in the hierarchy is second in command. Next, in 2011, the writ petitioner was sent on deputation for the service of the Honorable Governor in Meghalaya. (2016), 25th, and where he was posted as ADC. By a decision of the Directorate General of Border Security Force dated 19 December 2016. Promotion was denied to him. The grounds were as follows. Whatever is it? The ground was that he had not undergone junior command course or training in connection with that. However, in that communication, there was a whisper of reconsideration of the case on the ground of representation by the petitioner. It appears that the result of such reconsideration was the decision dated 28th April 2017 and yes, whatever is it? Yes. That reconsideration was duly considered or duly acted upon and resulted in the decision dated 28th April 2017 Learned Deputy Solicitor General has shown me the relevant rules from the affidavit in opposition filed by his client, which appears at which rule as well as the decision thereon appears in the annexure to the affidavit. Secondly, at page 65 of the affidavit in opposition containing the relevant part of the rule, it is stated that a deputy commandant in level 2 with 5 years regular service in the grade with total 10 years Group A service would be eligible to promotion to the post of second in command, provided he should have successfully completed pre-promotional course or courses as prescribed by the Director General, Border Security Post from time to time, and 2 years service as Deputy Commandant in a duty battalion or as Regiment Commander in Border Security Post. The relevant part of the rule is set out here under page, this is 65. Mark portion. This and this. Admittedly, the appellant does not fulfill the eligibility criteria of having undergone pre-promotional course or 2 years service as Deputy Commandant as prescribed in the rules. Paragraph. The submission of learned counsel for the petition has some substance when it was said that his client was sent on deputation by the decision of the ministry and not by his own volition. Nevertheless, what is germane is that when he was sent on deputation, he was made aware of the risk of it, that is, losing the chance of promotion for being unable to take the promotion course or to render service in the battalion. In spite of that, the appellant furnished two undertakings which are at page 49 and 50 of the affidavit in opposition that he would forego such opportunity and accept the deputation. Paragraph thereafter, after the deputation, came to an end in 2016, the appellant, the petitioner, could not have turned around and claimed promotion on the same footing as his colleagues. Full stop. It may be said that he has been subsequently promoted to the post of
Vice.
second in command.
On 7/11/17.
On 7
11/17.
17. The retrospective effect that he wants cannot be granted. In parting, I would add that
My lord,
although the
my lord, the petitioner here relying on the judgment, petitioner here relying on the judgment passed by the Honorable Delhi High Court, whereby my lord, similarly situated person has been given the benefit.
the officer gave an undertaking.
My lord, no undertaking was brought before by the respondent, my lord.
Then what have I said? No, but then next. Although I am unable to grant any relief in the writ petition, I would add the following. The writ petitioner has rendered bona fide service on deputation. Full stop, there is no complaint against him. this posting prevented him from acquiring the eligibility for promotion to the post of second in command. Subsequently, he has been promoted. I would only direct that whenever he is due now for further promotion, his case should be actively considered so that the next promotion is acquired by him in the fastest possible time. That's all.
Right. Very fair order.
The writ petition is disposed of accordingly.
This is
Number 2.
Yes.
Lordship. Your Lordship, the petitioner had, she's a young woman, Lordship, female constable, Lordship, in the Assam Rifles. She joined the Assam Rifles in the year 2015, and she was invalidated from the service on medical grounds, Lordship, in 1 year subsequent, Lordship. That is in the year 2016, Lordship. The petitioner is before your Lordship with a very limited prayer, Lordship. What has happened, Lordship, is in the medical report, on the strength of which she was invalidated out of service, Lordship, no percentage of disability has been mentioned, Lordship. Now, what has got done is that has prevented her from claiming any benefit, Lordship, which is equitable to her, Lordship, from the department, Lordship. Lordship, would kindly come to page number 20, Lordship, of the affidavit filed by the Union, Lordship.
So you first give us the facts.
Lordship, what
What
is
is the affidavit? Give us the facts.
Lordship, the petitioner joined the Assam Rifles as female constable in the year 2015, Lordship.
Yes.
And she was sent for training, Lordship. And while undergoing training, she suffered an injury, Lordship, and she reported to the medical doctor on duty. And there she was examined, and she was sent for further medical examination, Lordship. And there she was diagnosed with coxsackie.
Yes.
Some injury of the hip, Lordship, which is technical.
Yes. So the question is whether it was pre-service or post-service acquired.
Pre-service and post-service. And also besides, Lordship, and no percentage of disability, the disability has not been quantified, Lordship. And what that has done is that for claiming any benefits under disability, Lordship, quota, percentage has to be specified, Lordship. It has to be above 20%, then she is eligible for certain benefit, Lordship.
So they have acknowledged it is the disability was acquired during service,
Lordship,
or was it a congenital problem?
Lordship, in their affidavit, Lordship, the union is taking a stand that she had an injury that existed pre-service, Lordship, but in the medical report which they have annexed, Lordship, in the counter affidavit, Lordship, there the specific question was asked, Lordship, was the disability attributable to the individual's own negligence or misconduct? So in what way? The question was no. The answer is no, Lordship. And parallel number 4, what is the present degree of disablement as compared with the healthy person of the same age and sex? Percentage will be expressed as nil of as follows: 5 to 6%, 10%, 20%. The answer is nil, Lordship. Now, Lordship, what has happened is that Assam Rifle has a group insurance.
When they have said it is pre-service disability, then you will not get any pension.
No, still not get. Lordship,
You have been discharged from service,
I've been discharged from the service, Lordship.
so you are not getting any pension
I am not getting any, Lordship.
because it was pre-service.
That is their stand, Lordship, but my stand is that it was not pre-service, and in their own medical report also they have contradicted their own stand, Lordship. And besides that, Lordship, I also want to take Lordships to one group insurance scheme which is floated by the Assam Rifle themselves, Lordship. Hearing, Lordship, if I may submit, Lordship.
Yes.
Just there. 36 of affidavit. I think 36 of which is available at page number 36 of the affidavit in reply, counter affidavit, Lordship, which is also available there. If my lord can come to page number
But
2.
we have to first establish that the disability is post-service.
Lordship, will indulge me for a second, Lordship, and if I may kindly read this page number 2, Lordship, the first paragraph. Disability cover for personnel discharged without earning pensionary benefit has been introduced with effect from 1st April 2014. Cover will be admissible to ARGIS members of both attributable and non-attributable cases who are invalidated out/released from pension with 20% or higher disability with less than 10 years of service, Lordship, which is my case, Lordship. And ineligible for
But you have to show it is during service,
Lordship,
not congenital. Who has determined that it is not in service?
Lordship, the medical report,
Where?
page number 16, Lordship. Page number 16, the relevant portion will be at page number 19, Lordship. Does the disabilities exist before entering service? The answer is no, Lordship.
Where?
Lordship, page number 19 of the medical report, affidavit filed by the Union, Lordship.
Yes.
Serial number 1, the specific question is, the categorical question, does the disabilities exist before entering service? The answer is big no, Lordship. That means the respondents themselves acknowledge that the injury did not exist prior to joining the service.
Where is the report? It did exist before.
Lordship, in our appeal, we had filed before the what's the reply? Lordship, page number 34 of the writ petition, Lordship. The relevant portion will be at page 36, Lordship, the last paragraph.
Thirty-four.
36, Lordship, the relevant portion. It starts from 34, the relevant portion will be 36, Lordship. If Lordship would kindly come to para F, Lordship. The disability of the petitioner, within inverted commas, old-healed Perthes disease with coxa magna LT hip is a childhood disease and has not occurred due to any injury during training. Therefore, her disability is not attributable to military service, Lordship. And Lordship, if I may also add, Lordship, notwithstanding whether the injury was prior to service or after service, Lordship, this group insurance scheme, Lordship, it covers both the cases, Lordship. Only requirement is that the disability has to be quantified. And there are certain amounts which are equivalent to the serving personnel who have been discharged on medical ground, Lordship. Because the percentage of disability has not been mentioned, she has been deprived of this opportunity.
Mr. Deputy, let a medical board be constituted and let it be reviewed. This is a very sensitive issue, and compassion is also required. If she has acquired it in service, let us not deprive her of her benefits. Just because the Lieutenant General is of the view, because there is a counter view of the government hospital.
My Lord, I'm fine with that, my Lord. But one thing, my Lord, which I just wanted to point out, my Lord, the same order my friend is referring to, page 36, my Lord. On the previous page, my Lord, page 35 will also kindly have a look, my Lord. It page 35 of the writ petition, my Lord.
Of the affidavit?
Of the writ petition, my Lord. This is the appellate order, my Lord, passed by the Lieutenant General, my Lord. Here, at page 35, we'll also subclause C, my Lord. I'll just read few lines, my Lord.
To review this by a medical board.
But only one medical board will review both aspects, my Lord, whether it was pre-existing or post-service disease, my Lord. One, and number two, if it was pre-existing, what is the percentage? If it is post, my Lord, what is the percentage of disability?
Yes. The case of the writ petitioner calls for a more detailed consideration and compassionate analysis and more compassionate considerations. Paragraph right from her inception in service, the writ petitioner complained she joined SM Rifles as a constable on 31st March 2015. Full stop. On complaining of pain around the right hip on physical exercise and exertion, she underwent diagnosis and the diagnosis was of a case of quotation old healed pethes, P-E-T-H-E'(S), disease with coxa magna, C-O-X-A-M-A-G-N-A, within bracket, LT HIP. LT based on the recommendation of the invalidating medical board, she was invalidated out of service. A writ petition was prepared in the High Court of Manipur when it was disposed of by their lordships of that court by directing the respondents the result of the appeal is the appellate decision is the impugned order before me. Dated 11 September 2017. What is the last sentence? Yes, it is passed by the Lieutenant General, Director General, Assam Rifles. The writ petitioner the Lieutenant General opined that the department had correctly ruled in invalidating the writ petitioner from service. Paragraph. Where is that government certificate? Government hospital? You showed me.
19. 19. Page 19 of the affidavit.
90 of the affidavit.
Yes, sir. Government, Lordship. Regional Institute of Medical Science, Impal, the medical report is at page 23, Lordship. Okay, that's all.
Page?
Page 23, Lordship, of the writ petition.
Where does it say that it is not congenital? The medical certificate?
Page 19 of the affidavit. Page 19 of my affidavit. Page 19, yes.
Page 19.
Page 19 of the affidavit filed by the Union, Lordship.
We direct the evidence.
Lordship has a counter affidavit. Page 19.
Please read.
Lordship. Counter affidavit, Lordship.
Yes.
Does the disabilities exist before entering service? This is opinion of the medical board, Lordship, and the serial number 1. The question is, does the disabilities exist before entering service?
However, the line in the opinion of the medical board at page 20 of the when was this opinion taken? Before the
This
legislature decided.
Lordship.
But please recast one line in the opinion of the medical board at page 20 of the affidavit in opposition. Activates a fresh consideration of this matter. Again, serial number 1, quotation, does the disabilities exist before entering service? Unquote. The answer of the medical board is no. The border security force has so far not acted on the opinion of the medical board, but has taken its independent decision. I am of the view that this matter requires reconsideration. The impugned order of the Lieutenant General dated 11 September 2017 is set aside. He is directed not he is. I hereby constitute a medical board as follows. I, one specialist in the field from the Government Health Service. I, one specialist selected by the Lieutenant Governor, one to be nominated by the Lieutenant General, and the third shall be a private practitioner to be agreed upon by the Lieutenant General and the state government. Health Service representative in the panel. The medical report will address the issue. Here, the writ petitioner consider all documents and make its recommendation to the Lieutenant General, who shall, following the recommendation and any other evidence that is before him, pass a reasoned order within 3 months of receiving the newspapers. All right?
Only one that aspect, my lord, will also to clarify that to examine that aspect whether it is a pre-existing disease and what is the percentage of disability period.
Yes. The medical board will give opinion pointedly. Now, it should be above constitution of the medical board, not newspaper, medical board. The Medical board will pointedly address itself on two issues: whether the disease in question was contracted before the writ petitioners joining service or after joining service. If it was acquired after joining service, what is the percentage of disability suffered by the writ petitioner? The writ petition is accordingly disposed of. Any other matter? Yes.
There is only one place Border Security Force Commission, this is Assam Rifles, my lord.
Assam Rifles.
This is pertaining to Assam Rifles, my lord.
Assam Rifles.
The Border Security Force.
Sorry. Yes, call the
Number
claimant.
3.
Leave your my lord.
Yes.
Why I'm playing with this matter can be taken up next week, madam.
All right. You are for the petitioner?
Madam, I'm for the petition.
Yes, on the prayer of learned counsel for the petitioner, this writ application is adjourned for the day.
This is the oldest matter, I think, in the High Court, my lord. 2014 matter.
Why you don't want to do it?
My lord, actually, my lord, Mr. Paul is appearing in this matter, my lord. He's out of station today, my lord. So I'm praying it next week, my lord.
Adjourn for the day, but you please take down. Miss Learned Deputy Solicitor General points out that this matter is the oldest one in this High Court. Full stop. No further adjournment ought to be granted in this matter. Shall be granted in this matter.
Did-
Much.
Yes.